Okay, I think we might kick off because we've got a lot to get through, lots of content. Good evening, everyone, and welcome to what I hope will be the first in a series of probably quarterly fraud roundup webinars. For those of you who don't know me, I'm Alison Clare. I am head of the Business Crime and Fraud Group within Chambers. And the purpose of these webinars is to not only give you an update as to recent case law, but also to introduce you, hopefully on a rolling basis, to various members of the business crime group within Chambers. We have a real depth and breadth of experience in defending financial crime. And if you want to know more about who and what we have to offer in that regard, then please do email me or link in with me as head of the business crime group, and we can provide you with further details. We have also just started a program of small drinks for solicitors to get to know members of the business crime group a little better. So if you would like to join in that new program, then again, please do drop me a line or link in with me. Just a couple of points before we begin. The speakers are going to use slides to deal with some of the points that they are making. Those slides will be available to download, I hope, from the Chambers website, together with some other content tomorrow. Or do feel free to email any of the speakers or myself direct. There will be a list of our emails at the end of the presentation, which you can take a picture of on your phone. In those slides towards the end, there are 2 pages of other cases of interest, which we don't have the opportunity or the time to speak to this evening. But nearly all of those cases are taken from the Chambers Fraud newsletter, which comes out monthly. It's prepared by Tony Shaw QC and Faris Baloch, who's one of the speakers this evening. You can access all present and past copies of that on the Chambers website if you go to the news and alert section, and you can also sign up to have that emailed to you on a monthly basis. So please do take advantage of that resource because it's really very helpful. Can I turn then to the speakers themselves who are taking part in this first webinar update? Take it as read that they all have business crime and fraud expertise and experience. So just a few additional words about each of them. Naomi Parsons, who's going to speak to us about updates in respect of unused material. She's 2008 call, and alongside her financial crime practice, she has a very strong public law practice, and she has been for a number of years a member of the Attorney General's civil list. Max Baines has been in a number of high-profile financial crime cases, including LIBOR and Forex. But alongside that, he's also a leading practitioner in sports law, particularly professional discipline. And in that regard, he has acted on a number of occasions for the Football Association and like organisations. Faris Baloch, who's 2003 call, he, like Max, is ranked as a leading junior in financial and business crime. And he has a particular expertise and interest in the use of artificial intelligence in investigations. And he has advised a number of corporates and agencies about that subject. And last but not least, Julie Jones QC, who many of you will know as our first female head of Chambers. She has been recognised this year as part of the Hot 100 Lawyers list, and she was the winner last year of Crime Silk of the Year. So you can probably guess from those accolades that she acts across a whole range of criminal cases, but she has a specialisation in financial and corporate crime. So without further ado, can I hand you over to the first speaker, who is Naomi. And Georgie, if we could have the slides up, that would be great.
Thanks very much, Alison. I'm going to focus on the Attorney General's guidelines because at the very end of last year, the Attorney General published disclosure guidelines which came into effect and updated the previous guidelines from 2013. And they also updated the supplementary guidelines on the disclosure of digital material. Just by way of background as to why they were updated on the back of a series of high-profile prosecution disclosure failings. And relatedly, in recognition, particularly in fraud, that practitioners were struggling to deal with overwhelming volumes of digital material. So that's the background to them. At point 1 of my slide, I've set out the review that gave rise to the new guidelines in case anyone wants the reference. As to the status of the guidelines, well, they're obviously guidelines, but they describe themselves as high-level principles, and they're to be accompanied or understood alongside an in-depth knowledge of the CPIA codes of conduct, codes of practice, which were also updated in 2020, criminal procedure rules, and also case law. The update really from 2021, insofar as digital disclosure is concerned, is that there is no update. So the guideline cases remain R&R, that's more commonly known as the Operation Amazon judgment, in which Lord Justice Leveson set out the principles to be applied in the disclosure of large volumes of digital material. And more recently are against CB, which was a case in which Lord Justice Fulford set out the principles of digital disclosure, in particular when dealing with digital material that's in the possession of prosecution witnesses and dealing with that balance between Article 6, right to a fair trial, and Article 8, right to a private and family life. It is in fact R against CB a sex case, but as Lord Justice Fulford said in his remarks, the guidelines that he set out were of much wider application. So that's the background. Turning to the guidelines themselves at point 3 of my slide, what's new in them? Well, broadly, there's a lot more material and it's been reorganized. And so instead of focusing on the duties of various participants in the disclosure process, there's now a focus on the stages of the disclosure process. So it's much easier to follow as a document, and it's much clearer to work out what's to be done by whom and when. Of perhaps most interest for fraud practitioners will be the updates to Annex A. That's the annex that sets out the approach to be taken for digital material. And there are a lot of changes or a lot of additions, more detail in the annex, and there is a document available with the highlights so you can see exactly what's changed in the new guidelines. But because of the time, I've just picked out 2 points from the guidelines that are perhaps worthy of note. The first is that there are changes to the section entitled Sifting and Examination, so the process of identifying relevant material. And that's at paragraph 36 of the annex. The guidelines say that where there's a large volume of material, the investigator can search by sample, keyword, and so on. Well, that much is obviously not new. What is new is the reference and approval of the use of artificial intelligence. And that's at paragraph 41 of the guidelines. Technology, and I quote, takes the form of search tools, such as algorithms or predictive coding. They are an acceptable method of examining and reviewing material for disclosure processes. So in other words, computer software, rather than a human being, is going to undertake the majority of the review. And that's new in the criminal sphere, at least. It's been happening for a while in civil cases, and the case of Pyro was a landmark ruling in which predictive coding was judicially approved. Disclosure in civil proceedings is or appears to be the way of the future, the direction of travel, and indeed Lord Justice Leveson in his Amazon ruling said that there was no reason why the criminal disclosure process can't learn from the approaches adopted in civil procedure. The second point of interest in the annex is that there are changes to the schedules, and that's at paragraph 50 of the annex. It's obviously a tedious but very critical part of the disclosure process and a fraud case, and essential to get right if there's to be any hope of effectively challenging the decisions on the disclosure process. The guidelines say that material should be listed in block, described by quantity and with a generic title. And of course, that much is not new, but what is new is that that is now to be the default position. So the position is to list in block unless it is otherwise necessary. So it might be that the hundreds of thousands of entries, quite literally on an unused schedule, could be on their way out, at least if it's possible to do block listing. That will please some, but to others, it should sound a massive alarm bell, because it seems that prosecutors are potentially at least being given a green light to list everything in block. And of course, that comes with a risk that meaningful detail is not supplied in the schedules. To some extent, at least, the annex anticipates that danger, and so has inserted a new paragraph 52, which recommends that if available, metadata as a file should be attached to the block list. That's at paragraph 52. So in practical terms, what that would look like is there would be a block list and then a metadata file, maybe an Excel file with filters that would contain data, for example, if it were emails to or from the individual, time, date, subject, and so on. And taken together with the listing and with the block listing and the metadata file, it's just about possible to see that the burden will be reduced on the prosecution when scheduling, whilst if one's optimistic, at the same time enabling parties to identify more easily items that they're looking for that might be relevant and disclosable. But of course, it doesn't get round the problem if the files if there isn't any metadata on the files, or at least no meaningful metadata available. So that's the 2 points that I wanted to mention in respect of the Annex A. Turning to point 4 of my slide, I mentioned at the start that the guidelines were intended, in part at least, to address high-profile prosecution failures in disclosure. And of course, these guidelines are new, and it remains to be seen what impact, if any, they will have. But the disclosure cases in 2021 will only serve to highlight why amended guidelines were needed. The first case that I have there is Hamilton and the Post Office, and that will be a very well-known case. The Post Office, who were the private prosecutor in this case, secured convictions for theft and false accounting, and they did so on a system, relying on a system called the Horizon Accounting System. Civil proceedings established that that system was flawed, and importantly, known to be flawed right from inception. The Post Office didn't disclose the unreliability of that system, and indeed there was some evidence that the Post Office didn't even want to retain some of the information which disclosed the fact that the system was flawed. So non-disclosure in that case gave rise to an abuse under both grounds. It was not possible to have a fair trial, and also that the prosecution was an affront to the conscience of the court. Considering that case in the context of the new guidelines, it's very hard to see that any amendment, whether it's to scheduling, reviewing, etc., could have made any impact on the disclosure failings. There was a wholesale disregard by the Post Office for the CPIA principle of disclosing material which either undermined or assisted the defence. The second case is the Crown against Woods and Marshall and SFO prosecution, also known as the Serco trial. And that was a trial which you'll also be very familiar with, involving the prosecution of 2 former Serco executives. They were charged with fraud and false accounting relating to artificially reducing profits on their MOJ contract. And the case collapsed as a result of non-disclosure failings, including the failure to disclose board minutes. These had in fact been reviewed, or at least in part, but identified as not relevant, so they therefore didn't appear on the schedule of unused. And as this unravelled at trial, Mrs. Justice Tipples said that the trial cannot safely and fairly proceed, and therefore refused an adjournment to allow the SFO to remedy the failures. Again, considering the case in the light of revised Attorney General's guidelines, it's just about possible that if the missed documents had metadata, I don't know if they did, but if they did, the prosecution or indeed defence might have been more easily able to search the folders over a particular period and potentially have picked up a document that had been miscategorised as irrelevant. The third and final case on the list is the Crown against Bloor. That also collapsed. That was at Southwark Crown Court in October. That was a case that Alison was involved in, so if she wishes to say anything about that, then I'll leave that to her.
Yeah, I think just a couple of words about that. That was a case, an investment fraud at Southwark, prosecuted by the CPS. It ran for 5 to 6 weeks at trial, and then the prosecution threw their hand in just before the close of their case because of disclosure failings. It's probably high profile is probably a slight exaggeration. It got publicity, I think, only because the collapse occurred during National Disclosure Week, rather unfortunately. And it's of interest probably only in the respect that the failings were pretty basic, twofold really. The CPS taking, I think, what they believe to be a hard line on disclosure, whatever that may be, but an example of which is dismissing defence requests as interrogatories rather than engaging with a substance that lay beneath those requests, so form over substance as an approach to disclosure. And secondly, tying in with Naomi's point, very poor unused schedule. So some items missing completely and really pretty poor descriptions of many items which did appear there. So of interest probably only to the extent of whether that is a one-off in that particular case or reveals more systematic problems going forward in large frauds prosecuted by the CPS. Thanks very much, Naomi. I think now we're going to hand over to Max to talk to us about the latest DPA.
Thanks, Alison. I'm going to talk briefly about the Amik Foster Wheeler DPA, which was approved by the court in July this year. The slide on the screen is an overview of all DPAs since the very first one in 2015. They are all SFO cases, as you'll know, and we can see highlighted in red Amik Foster Wheeler being the 10th DPA of all time. It also shows a clear acceleration in the use of DPAs by the SFO, probably 5 across the first 5 years, and then 5 in the year since 2020. You'll also see entry 11 beneath Amik Foster Wheeler, a DPA agreed with 2 companies for bribery act offences. That DPA remains confidential, so we don't have any details on it. So I'm going to focus on Amik Foster Wheeler. Over the page, please. We can see this is an overview of the key ingredients of the DPA approved by Lord Justice Edis on the 1st of July of this year. Foster Wheeler, as they were at the relevant time, operated, no surprise, in the oil and gas sector. The offending period was 1996 to 2014, so relatively historic, but over quite a lengthy period of time through the use of agents and intermediaries, and perpetrated, importantly, at a high level in the company by senior employees. the total financial penalty, and that comprises of the disgorgement of profits, the fine, and the SFO costs, came to £103 million. And that itself was part of a wider global settlement, which included the US and Brazil, giving a total global settlement of $177 million. There was also, unusually for a DPA, compensation agreed in this case to the people of Nigeria for what may appear to be a derisory sum in the context of the overall value of the DPA of just over £210,000. I'll return to that in a moment. Seems to me there are four key takeaways from this DPA. Firstly, the critical importance of self-reporting. That's an issue, of course, which has been highlighted in a number of previous DPAs. Secondly, change of ownership, and this was probably the key factor in this DPA being approved, because the company which is currently the owner of Amik Foster Wheeler is entirely unconnected, both in ownership and management, to the company as it was during the time of the offending. Thirdly, the clear emphasis in the DPA and in the judgment to the fact that no findings of fact were made against any individuals. And finally, one or two comments made by Lord Justice Edis about the approach that the SFO took to the calculation of the financial penalty. So dealing first of all with self-reporting, in fact, despite getting a DPA, Amik Foster Wheeler did not self-report. They essentially did the opposite. And between 2007 and 2009, in what Edis called a cleansing process, they commissioned a number of legal reports for their board into corrupt activity which had taken place in their business in Malaysia, Nigeria, and Saudi Arabia, and then promptly took no action whatsoever in terms of addressing the issues which were set out in that report, which of course then allowed the same corrupt activity to continue for several years after that date. And while Edis noted that there is no legal duty to a board to self-report, in these circumstances where the corrupt activity had been so clearly evidenced to the board, the failure to report was, in his word, deplorable. And by extension, the anti-bribery and corruption policies, which can be a significant factor in DPAs and demonstrating the general culture within a company, were worthless because the written word within those policies simply wasn't reflected in the action of the company, and therefore no weight could be attached to those. In addition to that, the criminality was found to be both widespread and at a high level in the culture of the company. And you may wonder then, given all of those factors, how Amik Foster Wheeler managed to secure a DPA at all. The next slide shows the key reason in this case was new ownership. And just looking at the bullet point about halfway down, John Wood Group, who are the current owners, are, in the words of the judge, twice removed from both the ownership and the management of the company at the relevant time. So in terms of background, Foster Wheeler, as it was at the time, was purchased by Amik in 2014, just at the end of the period of criminality. Amik Foster Wheeler was in turn purchased by Wood Group in 2017. And in that sense, they were deemed to be two steps removed from the original company. And Edis made it clear that but for that fact, he would not have approved a DPA in this case. And just skipping to the top bullet point, while I've said there was no self-report, the judge said that actually self-reporting during the course of the investigation was an essential factor. It seems a bit of a misnomer to describe a self-report coming after the start of an investigation, but it's really a reference to the conduct of the new company and their full cooperation with the SFO and the robust governance systems which they put in place, which had been absent before their ownership. Next slide, please. The exact timing of Wood's acquisition was an important question, and it was a question that Lord Justice Edis put to the parties in the preliminary hearing, namely, did they purchase Amik Foster Wheeler before or after the SFO announced its investigation in 2017? Now, the answer was just after, but they had made their offer to purchase AFW just before, and they stood by the offer and the value of that offer and didn't seek any discount in order to reflect the clear liabilities that were coming their way as a result of the SFO's investigation. And that was important for two reasons. One, it genuinely meant that they were not in any way tainted by the previous criminality and could be treated as an entirely innocent party who found themselves in the unfortunate position of carrying the can for liabilities accrued by AFW. But it was also important because it meant that they could receive a discount within the financial penalty. In other words, they wouldn't have been entitled to that if they'd already had a discount on the purchase price. That would have been a double discount. Over the page, prosecution of individuals. A decision on individual charges was said in July to be taken within, would be taken within 3 months. I'm not aware of any decision to date. In any event, there is a very clear emphasis writ large across the DPA and all the commentary around the DPA and in the judgment, making it clear that the DPA in no way impinges upon or prejudices the prosecution of any individual in the future. Presumably, that's been done because the SFO's track record in prosecuting individuals who are connected to companies who have agreed DPAs has been poor. And so in emphasizing this on their website, for example, which reads the DPA only relates to criminal liability of AFWEL and does not address whether liability of any sort attaches to any other person, including employee, agent, former employee, or former agent of AFWEL. Presumably the purpose of that is to protect the integrity of any future prosecution of an individual. And over the page, we can see that it is written into the preamble itself to the DPA. And without going through the whole of that quote, it says the court did not make findings of fact. It never does, but it's never been emphasized in this way in other DPAs. No process took place by which the culpability of individual people was determined. And then further down, the judgment in the DPA solely dealt with the culpability of the company, Amik Foster Wheeler Energy Limited, and not that of any individual person. No findings of any kind were made against any individual. So it's repeated and emphasized throughout the DPA and the preamble and the commentary and in the judgment. Just finally, calculation of the penalty. Lord Justice Edis was a little critical of what he described as an overly mechanistic approach to the financial penalty by the SFO. They followed, as they are bound to, the sentencing guidelines. So there is a sentencing guideline, of course, which covers fraud cases, bribery and corruption. And that is used in exactly the same way that it would be used in any regular prosecution in the Crown Court. And one of the basic principles is that when assessing the correct penalty in a DPA, it should be broadly comparable to the position of a company pleading guilty in the Crown Court. The other important principle is that it must have real economic impact, but not undermine the commercial position of what was, in this case, an entirely reformed company. Now, there was a 50% reduction for Wood Group being twice removed from the original ownership. And that's the point I touched on earlier about the timing of their acquisition and the fact that it came just before, at least the offer to purchase did, the investigation was announced. Now that 50% isn't half of the financial penalty, it's 50% of the multiplier, which is used in order to calculate the gross penalty from which various reductions are made. And that 50% was approved by the court. Just finally then, the compensation figure, £210,610 to the people of Nigeria. It's unusual in DPAs to have any specific compensation like this ordered. In fact, it's only happened once before, for the simple reason that while bribery and corruption is obviously very damaging for the local communities and people of the countries where it's perpetrated, it's very difficult, generally speaking, to put any monetary figure on that damage. In this case, it happened that there is a civil tax claim by the Nigerian authorities against Amik Foster Wheeler, essentially around tax evasion, and the difference between the tax claimed and the tax paid is that 210,000 figure. And so it was agreed that that should be added in this case to the overall financial penalty. And that was a very brief canter through the Amik Foster Wheeler DPA.
Thanks very much, Max. And before we just turn to Faris's section on the evidence, I think the other thing about the DPA that's worth bearing in mind is the role of the parent group's undertaking. The terms of that undertaking are on the website of the SFO, and it's worth a read. And I think particularly interesting that the court took the view that one of the reasons it would approve the DPA is because that undertaking by the parent would have been more effective than any available serious crime prevention order had this case been prosecuted. So I think that's another interesting angle to this particular DPA. Thanks very much, Max. And I think now we're going to turn to Faris and some evidential cases.
There are three cases that I'm going to review, which I think are significant on the topic of criminal evidence. They're all quite different. The first is Sally Jones, which concerns private prosecutions, Norwich Pharmacal orders, and the privilege against self-incrimination. The second is Byrne and others, which is about expert evidence. And the third is A and others, which is the Encrypt case. So if we go to the next slide. So Jones, this, by way of background, a company called DAS suspected it was the victim of a fraud by its senior officers and by Sally Jones. DAS suspected its CEO and others had abused their position in DAS to give contracts to Sally Jones' company, MedReport, in which they had a secret beneficial interest. DAS sought a Norwich Pharmacal order to obtain information about MedReport's beneficial ownership. Now, just forgive me if you're all familiar with Norwich Pharmacal orders, but just for the benefit of those who are not, Norwich Pharmacal order is a disclosure order that can be applied for at the High Court, which allows information to be obtained from third parties that have become mixed up in wrongdoing. And there doesn't need to be any civil or criminal litigation in progress. DAS's application was made on the basis that MedReport was mixed up in the fraud. DAS said there were allegations about the senior officers, but that any civil or criminal case would be at best inferential without the disclosure that they sought. They argued that the documents showing beneficial ownership would put the matter beyond doubt because they might show that Jones was holding shares on trust for senior officers of DAS who'd kept their interest hidden. At the hearing, it's important just to note that Jones was represented by counsel and solicitors, and she didn't object to the order so long as it related to tightly defined documents. The High Court then made the order and the documents requested were produced. And those documents incriminated Sally Jones and others. And when the police declined to prosecute, DAS commenced a private prosecution. Now, at the trial, the criminal trial, the prosecution sought to rely on the documents obtained, and the judge rejected the defence application to exclude the documents under Section 78. And he ruled that there was no unfairness in the way that the documents had been obtained. And Jones was convicted at trial. She then appealed, and on appeal, she argued that she hadn't been identified in the application for the Norwich Pharmacal order as a potential defendant. So she was saying that if she had known that she might be a defendant, then she would have claimed the privilege against self-incrimination, and the order wouldn't have been made. So privilege against self-incrimination, the common law privilege that no person is bound to answer any questions in civil proceedings if the answer would tend to incriminate them. Prosecution said that Jones had been represented in the proceedings, which were inter partes, and the decision not to claim the privilege must have been deliberate. And you can just see up on screen that the Court of Appeal agreed with the prosecution. So that we accept the submission that Jones's solicitors must have considered the question of self-incrimination. The application was made inter partes with experienced criminal solicitors acting, and the possibility, at least, of criminal proceedings against the party producing the documents was clearly raised. The fact that these things were not done does not, in our judgment, mean that the use of those documents in the criminal proceedings rendered those proceedings unfair. The fact is that no claim to privilege against self-incrimination was made. In the absence of any evidence to the contrary, the judge was entitled to infer that this was a considered and deliberate decision. If we go to the next slide, the court didn't actually get into the question of whether or not Jones had a valid claim to the privilege. And I just want to look at briefly what might happen in similar circumstances if the privilege is raised. If it had been raised, that's perhaps a separate question, but if it was to be raised in similar circumstances, what might happen? In Sally Jones' case, the documents that were being requested were pre-existing documents, as opposed to statements or admissions in answer to questions. And the authority on that is Volaw Trust, which is a Privy Council case, which sets out the factors that need to be considered. And those are listed. They are the nature and degree of compulsion used to obtain the documents in question, the weight of the public interest in the investigation and punishment of the offences in issue, and the existence of any relevant safeguards in the procedure, and the use to which any material might be put. Now, it's important to note that Volaw hadn't been decided at the time of the High Court proceedings in Jones. So that's pre-existing documents. Those are the factors, but it's different if the claim to privilege is in respect of admissions or statements. There, Section 13 of the Fraud Act applies, and that gives protection. Because whilst the individual must answer questions or comply with the order, those statements or admissions are not admissible in any criminal trial. But I sort of concluded from looking at this case was that if a defendant believes, or someone who might be a defendant believes, that documents sought from them might be incriminating, it is worth considering raising the privilege, because the court might not order disclosure, But even if it does order disclosure, an application to exclude the documents later at any subsequent criminal trial would be stronger. So that's Jones. The next case is Byrne. This is about expert evidence. Byrne and others involved a number of appeals, all related to the same expert in carbon credits called Andrew Ager. He gave evidence in 14 criminal trials between 2012 and 2019 on topics such as the viability of carbon credits as an investment and whether a secondary market existed. At a later trial, in May 2019, he was discredited at a voir dire and abandoned as a witness by the prosecution on the grounds that it was accepted that he was not an expert of suitable caliber. It had been established that he had not received training in the duties of being an expert. He'd withheld important concessions from the defense. He had no relevant academic qualifications, and he couldn't even remember if he'd passed his A-levels. He'd made no attempt to comply with the CPR. He hadn't retained records as required. And he'd improperly dealt with a defense witness to avoid challenge to his own evidence by someone who was more competent. The appeals against conviction all failed. If we just look at the first bullet point, the court said that the fact an expert witness has been discredited for unprofessional conduct does not render unsafe earlier convictions imposed at trials where the expert had given evidence which remained unchallenged. And the evidence hadn't been challenged in the earlier cases because the defense case was run along the lines that the defendant had an honest belief that he was not defrauding investors. And so the evidence that Ager gave about the value of the investments being unrealistic and the lack of a secondary market was never challenged. And none of the defendants actually served their own expert. The court also concluded that a lack of formal qualifications was not in itself determinative of whether an individual was entitled to give expert opinion evidence. The court said that although Ager's lack of qualifications should have been made clear, it was not determinative whether he was entitled to give the evidence. And the court confirmed the main authority on this topic, which is Paybon, which is a 2018 case, that a general expertise in a particular area may suffice. You don't need formal qualifications. I'm just going to very briefly go to the next case. I think I'm running out of time, which is the Encrypt case. Encrypt was an encrypted mobile phone system used by criminals with dedicated handsets that were marketed as totally secure. Messages from one user to another were encrypted as they passed through the Encrypt server, and then they were decoded on the receiving device. But it wasn't that secure because the French police uploaded an implant to all Encrypt devices in the world under cover of an update. And that implant caused the device to send all its messages and any new messages to the French police's server. Material obtained in this way was then shared with the UK authorities. And the issue was whether the communications were admissible. So there was a preparatory hearing where this issue was raised, and there was a lot of expert evidence on the topic of how the communications had been intercepted. The question of admissibility turned on whether they'd been intercepted during transmission from one user to another, so sort of mid-flight, or whether it was the case that the messages stored on the device, whether the senders or recipients, were being sent to the police server. And the court concluded that they were not intercepted during transmission from one user to another, but from the storage, and therefore they were admissible. Had the court concluded that they were intercepted during transmission from one device to another, they would have been inadmissible. That's a quick run through of those three cases.
Thank you so much, Faris, for dealing with those evidential cases. And I think we're now going to hand on to Gilly to look at some fairly recent confiscation-related decisions.
Good evening. If I can just go to the first slide, I'm going to look at 4 cases. The first is a very recent decision of the Supreme Court in the case of CPS against Aquila Advisory Limited. In fact, the judgment was handed down on the 3rd of November of this year. Now, this is the most recent opportunity for the Supreme Court to consider the principle in the case of Bilter Limited against Nazir, which is a previous decision of the Supreme Court dating back from 2015, which concerned whether the intentions of dishonest directors could be attributed to their company. By way of a quick overview of the facts of this case, Mr. Thatched and Mr. Perrin were directors of a financial services company called Vantis Tax Limited, prosecuted, convicted of cheating the public revenue. In a nutshell, the directors devised a scheme to defraud the revenue by purporting to sell IP rights owned by VTL from a trust which didn't exist to various companies in order to artificially inflate the share values of those companies. And this then, of course, enabled taxpayers who'd earlier subscribed to those shares to donate them to charity at that inflated value, and then claim tax relief in excess of the subscription value of the shares. In the meantime, the directors siphoned off the funds paid into those companies, amounting to about 4.55 million. Post all of this coming to light, VTL went into administration, and Aquila was then assigned VTL's proprietary rights. Now, following conviction, the CPS sought a confiscation order under the Proceeds of Crime Act against those 2 directors, Mr. Perrin and Mr. Thatchney. Now, at that point, Aquila Advisory Limited, to which the company VTL's rights had been assigned, sought to intervene and sought to establish and enforce what was said to be a constructive trust over those unauthorised profits. So in other words, the 4.55 million that had been siphoned off, which then had been personally obtained by the directors. And indeed, it was that sum which was determined to be their benefit figure pursuant to the prosecution and confiscation proceedings. Now, Aquila argued that because it had a proprietary claim to that 4.55 million, its claim took priority over the confiscation orders, which did not give the CPS any form of proprietary interest. Now, of course, if that was correct, Aquila would be entitled to all of the directors' assets, leaving nothing to satisfy the confiscation orders. Crown prosecution challenged the claim to the constructive trust on the basis that the acts and knowledge of the directors were to be attributed to the company VTL, and the claim therefore failed for illegality. Now, at first instance, the trial judge found in favour of Aquila and granted a declaration that the 4.55 million was indeed held on constructive trust in favour of VTL, whose rights had indeed been assigned to Aquila. Further, and in accordance with the agreement of the parties, the trial judge then declared that the CPS was obliged to give instructions for the transfer of the net proceeds that have been realised from all of the assets listed in the confiscations over to Aquila. Not surprisingly, the CPS appealed. They appealed to the Court of Appeal Civil Division, and the CPS argued that the director's actions should have been attributed to VTL, and thus VTL should have been barred from recovering any proceeds of crime because of the principle of illegality and or on public policy grounds. For those who don't know what the principle of illegality is, it's that the person should not be permitted to benefit from his or her illegal act. Court of Appeal dismissed the appeal. The CPS then appealed to the Supreme Court, and the issues I've set out in the slide for you. They were where a proprietary claim is brought by a company against its directors to recover proceeds of crime received in breach of a fiduciary duty. Firstly, can that proprietary claim be asserted in priority to a confiscation order obtained by the Secondly, can the illegality of the directors be attributed to the company in circumstances where the company suffered no loss and stood to profit from the crime? Now, Lord Stevens in the Supreme Court delivered the judgment, and in fact, all 5 judges were in agreement. They considered each of the CPS's grounds and dismissed each in turn. In respect to the first ground, the court dismissed the argument and found that the reasoning in Bilter applied in the case. In other words, that unlawful acts of dishonest state of mind of a director cannot be attributed to the company to establish an illegality defence, defeating the company's claim under a constructive trust. On ground 2, the Supreme Court found that the overall scheme of POCA is not to interfere with proprietary rights. Furthermore, although there are specific provisions of POCA which allow the state to override property rights, those provisions were not engaged by the CPS in this case. As a result, the court found the decision of the Court of Appeal was not inconsistent with POCA and the regime. Finally, the CPS argued that even if the unlawful conduct of the former directors cannot be attributed to VTL, then the trial judge in the proper exercise of his discretion ought not to have granted Aquila any declaratory relief. Now, the court found in the context of this case a constructive trust, so therefore VTL's beneficial ownership of those secret profits arose automatically when the directors breached their fiduciary duties. At no stage did the directors therefore own the secret profits in equity. The court found the trial judge's order therefore recognised that reality, and it was a proper exercise of his discretion. So what's the impact of this decision? Well, it leaves the defrauded party out of pocket, of that there's no doubt, but it said it's gone a long way to addressing the interplay between the regime under POCA and the enforcement of the common law. This provides some degree of clarity on the breadth of the Bilter principle and the relevant factors that can be considered, with the court emphasising the importance of certainty in the rules concerning breaches of fiduciary duties. So in essence, it confirmed that the basic structure of POCA is to respect and not to interfere with third-party property rights, except where expressly it so provides. So that's for a sort of quick dash around the finding of the Supreme Court in Aquila Advisory Limited. I'm going to go then, please, to the next case. Now, we've touched on this already. In fact, the Jones in this case of Aspling, Kearns and Jones is the one that Farris spoke about a moment ago when dealing with evidential issues, but this was an appeal about a different aspect, the confiscation order. In a nutshell, the court held that where 3 defendants have been convicted of a conspiracy to defraud their employer, confiscation orders against them, which included their salaries in the calculation of benefit obtained, were not disproportionate. So the commission of the fraud meant that their employment, and hence their right to their salaries, was fundamentally flawed. The facts you've already had touched upon, and this is the company DAS, which ensured the costs of litigation brought by insured clients against third parties, including claims for personal injury. Mr. Aspling, the first defendant, was the managing director and CEO. Mr. Kearns was employed in a senior role as head of claims and the general manager of DAS. Prosecution case, as we've had outlined, was that those defendants used that status in effect to exploit the way in which DAS did business and to allow them to make a secret profit without DAS being aware of their actions. This, of course, being in breach of their fiduciary duties, which they owed Aspling and Kearns, and was contrary to the strict policies within DAS to prevent conflicts of interest. And the fraud, as you've had outlined, involved a company called Medreport, that in fact had been established by Aspling and Kearns back in 2000. And in carrying out its business as an legal expense insurer, DAS required medical reports. And the conspirators had set up Medreport to provide those reports, but they kept their interest in Medreport hidden from DAS. So Aspling and Kearns working at DAS while in effect owning Medreport. Sally Jones, She was a manager of Medreport and later an owner and director, continuing to run the company after Asplin transferred his interest in it to her, each convicted of conspiracy to defraud DAS and other associated offences. Confiscation orders were made against all three defendants. And within those confiscation orders, in determining benefit, their salaries were included. Now, the defendant all appealed, and the registrar referred the applications for leave to the full court. Now, there were various grounds, but for the purposes of today, I'm just going to focus on the ground in which it was argued that the judge was wrong to include the entire salary and bonus paid by DAS to Asplin and Kearns in the calculation of the benefit obtained by them, as either as a result of or in connection with the commission of the offences. And in turn, that it was wrong to treat Miss Jones's salary from Medreport as benefit for the purposes of the confiscation order. And it was argued that to do so rendered the confiscation orders disproportionate. Now, having heard argument and looked at and done a review of the various cases that looked at whether an employee gave value for their salaries, the court, in giving judgment, emphasised that identification of the benefits obtained as a result of or in connection with the commission of an offence is always fact-specific. However, in respect of Kearns and Asplin, it was common ground that they would have been sacked if their true position had been known. They therefore obtained their salaries as a result of concealing their interest in Medreport. That concealment, in circumstances where they owed a fiduciary duty to disclose their interest, was of course an integral part of the conspiracy and indeed formed one of the particulars of the fraud in the indictment. In those circumstances, the court held that the judge was quite right to conclude that the salaries obtained by Asplin and Kearns were obtained as a result of or in connection with their commission of the offences. As to proportionality, it was accepted that a considerable part of Asplin's and Kearns' work at DAS was in fact unconnected entirely with the direction of work to Medreport and the receipt of those secret profits. And that in many respects, Asplin and Kearns had indeed contributed to DAS's overall success. And they provided at least some and perhaps even significant value for the salaries that they received. However, it was impossible to sever and quantify the legitimate work done promoting DAS's interests from the illegitimate work done connected in relation to the commission of the offence. Any attempt to do so, it was said, would be to pluck a figure from the air. In such circumstances, Asplin and Kearns, therefore, could not be regarded as having given full value for the salaries that they received. Accordingly, to treat the salaries received by Asplin and Kearns as part of the benefit which they received in the commission of the offence was held not to render the convictions disproportionate. Sally Jones, her position slightly different. She was employed by Medreport and not by DAS, the victim of the offence. However, it was held that the judge was right to find that her salary too was obtained as a result of or in connection with the commission of the offence. Without the conspiracy, Medreport would indeed have had no business. Again, the analysis of proportionality in her case took a similar line of argument to that in the cases for Asplin and Kearns. The one adjustment the court did make was that in all three cases, the salaries included a calculation of benefit on the basis of gross salaries and not salaries paid net of tax, which the court held should have been the correct position. And so they adjusted accordingly. So what's the practical implications? Well, the takeaway is that when you're dealing with advising a dishonest employee about potential confiscation proceedings, that even if they competently perform their role as an employee, it shouldn't be assumed that it's going to be disproportionate, applying those proportionality requirements to include their salary in the calculation of benefit. And that's so even if it's possible to argue that they have done value for money or offered value for money. So key issue is, can you identify legitimate activity? If you can you evidence it? Confiscation is always on the defendant in those circumstances to be able to provide evidence. Firm factual basis is needed. Without it, no discretion to just plug a figure out of the air, and that means full salary would be included. The last two cases I'm literally going to give you the headlines of because I see the time. Just so they're on your radar, Collins against DPP, appeal by way of case state. It's quite a novel argument. It's in dismissing the appeal, it was held that where hidden assets orders have been made in confiscation proceedings pursuant to the Proceeds of Crime Act against co-defendants, with the amount owed to be reduced in the case of each defendant by the sums paid by any in respect of it. So the Ahmed and Fields line of proportion. In essence, so the state doesn't claim or get the benefit more than once of a confiscation order. What was argued was whether that indeed or that principle could also apply to periods of terms of imprisonment in default of payment. The court held that it did not mean the time to be served in prison by a defendant in default of payment should be reduced in the same way. The default term was calculated to exert sufficient pressure on a defendant to ensure the order was paid, and reducing it to reflect someone else's detention would, of course, undermine the statutory purpose. And last but not least, just so that you have the headlines. Next slide, please. The case of Parcheska. This was case conspiracy, organised crime group. The defendant in this case was part of a family business that specialised in the trafficking of men and women. She was found on her appeal against her sentence to be in the lesser role category for sentence. And when it came to the confiscation order, she sought to argue that that in effect meant that she should be approached in the same way for confiscation. The prosecution said not so. The appellant was, for practical purposes, an equity partner who'd obtained the full amount of the value of the conspiracy, which accordingly should be declared as her benefit. On appeal, the Court of Appeal dismissing it held that the judge was right to find that for asset recovery purposes, the appellant was a co-obtainer of the total benefit of the proceeds of crime so as to justify that confiscation order against her. The fact that the Court of Appeal had found she played a lesser role for the purposes of her sentence appeal and the sentence length did not govern the position regarding the confiscation order. So that's a bit of a rattle through, but to give you a few of the highlights of the confiscation rulings or decisions in the last year.
Thank you so much, Julie, for dealing with those confiscation cases. And George, if we could just move on to the next two slides, not to go through them, but just to show you in the next one, anyone who's still with us, that you can download the summary of these 7 other cases and the references. If you just move to the next slide, Georgie, they will be available either through us from email or on the website tomorrow, I hope. And then the final slide, if you need to contact any of us about anything that's been said or generally about the crime group, there are contact details. Can I just say thank you to all the people who spoke this evening. I know at least 2 of them are themselves in the middle of a trial out of London, so it was no small ask. Thank you very much, and thank you to everyone for joining, and I hope you found it helpful.